And so we are now recording right now. And again, welcome to another episode of the COVID Clarity series. I'm Stephen Christian, and I'll be your moderator for the second edition of the series, where we will be exploring the rules of engagement and navigating employment law. And since March 2020, the COVID-19 epidemic has created significant challenges for employers who are trying to keep their businesses up and running. To add to the practical difficulty of operating during a pandemic, changes in local and state and federal laws are making things considerably more challenging. Here to help us navigate the complexities of these rules and regulations is our business expert, attorney Greg Lockwood, who is a partner in Gordon Reese Scully Suscani's Portland office, where he represents businesses, executives, and professionals in courts, arbitrations, and administrative proceedings across the country. Locally, he assists Northwest employers defend against claims asserted by their employees and counsels them on best practices in complying with employment laws and avoiding litigation. Greg focuses on providing efficient and business-oriented results. The COVID Clarity series is sponsored by the Seoul District Business Association, Gordon Reese Scully Suscani, and Sussman Shank, and moderated by Flossin Media. If you have questions throughout the presentation, please add them to the chat and we will get to them and address them during the series. There will also be opportunities for group discussions at the end of the presentation as well. Now let's get into the presentation and explore with Attorney Lockwood some of the most recent changes to employment laws, as well as some crucial employment topics for handling your workforce during the pandemic.
Good morning. My name is Greg Lockwood, and thank you so much for joining us today. Just a little bit about who I am beyond the very kind introduction that Stephen just gave me. I am a litigator primarily, so I am the guy that you typically don't want to see either because you have been sued or because you're trying to avoid getting sued. That's primarily my role. So my perspective on these issues comes from the perspective of somebody who's trying to mitigate risk and keep you from being in a situation where you end up in a lawsuit. So one thing that's sort of good to know is that it's okay to make mistakes. You're going to get away with most of your mistakes, but you want to avoid them as best as possible to avoid getting into a situation that becomes cumbersome and expensive. So a lot of today is going to be about that. If you don't take the smart steps leading up, in managing your workforce, the situation can be catastrophic. It could end your business. So these things are important to kind of keep in the back of your mind as you're approaching dealing with the new business environment. Bryson Davis, my friend over at Sussman Shank and a fantastic corporate attorney, and I came up with the idea of doing a series like this because, especially at the beginning of the pandemic, we saw that the rules and the laws coming from the state, federal, local government were at times inconsistent, often not clear, and left a lot of ambiguity about what could and could not be done. Oregon is a small business community. It relies on vibrant small business owners to kind of be the driving force behind making our community work. And those folks don't usually have an attorney on staff, and many don't even have an attorney on retainer. So some people, I don't think, had the right support or information to continue operations or to operate safely. So that's one of the things that Bryson and I wanted to kind of get out there and help people with as this continues to go on. So the thing that really kind of struck at home for me is that I had a client who was a contractor, and this contractor did business on both sides of the Columbia. And he did not think that he could operate because of the shutdown. It turns out in Oregon, that wasn't true. In Washington, it was true, maybe, potentially. There were some things that he could have done. But there was a time where he could have been making money, could have been continuing on projects, but was just stopped. And so hopefully the things that we discussed today and the resources that we provide you with throughout this will give you and your colleagues more of an opportunity to deal with these changes, look at what's coming forward, prepare for them, and be in a good position going forward. So just as a couple of things before we get into this in earnest, some caveats. We're lawyers. We love to have limitations of liability, exceptions, so that we can cover ourselves. But also this is to cover you guys. It's important to realize that these rules are constantly in flux. There are new regulations coming out from all levels of government at all times. The CDC guidelines change frequently. There's just a lot going on right now. So staying on top of these things, being proactive, listening to what your colleagues are doing in the rest of the business world, super important. In addition to the fact that these things are being developed and changed in real time, is that the laws and rules have not gone all the way through the system yet. We're in a common law system. So what our courts decide and how they interpret the rules are important to determining how these laws are going to be applied in practice. So we don't have the benefit of that yet in most cases. So there's a lot of things that could be changing from that perspective too. And then finally, your individual business's situation is unique. What we are discussing today may not apply to you, may be different for your specific business. So if there are specific questions or if a situation is arising, it's always best to go and talk to somebody about what's actually going on so that they can give you the best advice for your particular situation. So first and foremost, with employment law, you always want to be proactive. You want to have things set up the right way up front. Most companies are going to use an employment handbook or some sort of set of employee rules and standards to be there. You don't have to have that, but it's highly advisable. And there's a recent change in Oregon law, specifically as it relates to the anti-discrimination statute, that really indicates that this is not only best practice, but it really is what you should be doing. The law changed on October 1, and basically it says that you as an employer, regardless of size, have to provide your employees with notice of your discrimination, anti-discrimination plan and procedures, as well as the statute of limitations and other restrictions on certain things that are done in resolving employment disputes. So it's good to have a handbook. It's good to have those policies in place. Once you have those in place, it's important to make sure that you're following them. It's good to go back and make sure that you know what your specific handbook says about your leave of absence policies, your time off policies, what you do when you're sick, whether or not 3 unexcused absences leads to a termination, things like that. Because if you know that, you're going to be able to apply it more evenly, and that prevents a whole host of problems that can arise if you don't. So first of all, have the system set up. Try it. If you want to do it yourself, you can. It's best to work with somebody who's expert in it. There are a lot of great HR companies in the area, as well as attorneys that have forums that can help you set this up, often for a price that's more affordable than you'd think. If you're not working with somebody, and regardless, you should always do your best to stay on top of what's going on in the state and the federal government with regards to the change in laws, because they do change often, and not adjusting what you're doing can have pretty significant effects. So just upfront, that's really what you should be doing. In addition to that, it's very important to communicate with your employees, especially during times of uncertainty. Your employees often have an idea of what's going on, what's impacting them, what they're seeing, and how it's going to affect your business. Having that dialogue is very useful in trying to address and solve and preempt some problems that can come up when operating, especially in these uncertain times. Unfortunately, this is a period where at times businesses have had to shut down. There have been layoffs. People have needed more time for themselves and their families. And some of these things kind of coincide in a way where you can avoid a big problem by simply having a dialogue with your employees. So, for example, if you have 10 employees, there might be one or two who you need to let go. But there also might be one or two in that group who, because of school closures, other family issues, they might want to leave. So you could have a situation where somebody would voluntarily leave where you would otherwise have to go through the process of termination, and skipping that is super valuable. You can avoid lawsuits, litigation, hard feelings, frustration from your staff, morale issues. Communicating with your people, knowing where they're coming from, allowing them to know a little bit about what's going on with the company is really important to kind of preventing some of those difficult situations. We already talked about the laws being in flux, but it's really important to kind of know the law and follow the law. And it's really, really important to follow your own rules, because when you do get into a situation where things go sideways, one of the first things that any plaintiff's attorney is going to look at is your own policies and whether or not you followed them. And following them uniformly across the board is kind of super, super important. So these things will help you avoid risks regardless of the time, but in times where economic pressures are greater and there's other emotions going in simply because of the environment that we're in right now, it's really important to kind of think about these things. So kind of generally speaking, we're currently in the midst of an ongoing pandemic. In the Tri-County area, Multnomah, Washington, Clackamas, we're still in phase one. The phase one restrictions for most businesses are relatively severe. They impact how your employees are able to work, and more particularly, they impact how you can interact with the public and your customers. So it's important that you understand those restrictions and be able to come up with systems to protect your workforce as well as continue operations. Unfortunately, it doesn't seem like the Tri-County area, based on what I've been hearing, is going to come out of phase one until basically we're in phase three as a country. So these restrictions are going to be here to stay, and coming up with ways to continue to operate and be efficient in this new environment is going to be important to maintain your business, probably for the next 12 to 18 months. It's unfortunate, but it's the reality. Most of the state is in phase two. If you happen to be one of the fortunate businesses that does have operations elsewhere, those loosen the restrictions a little bit, allow more people to come into your business, and just allow you a little bit more flexibility. But really, we're not talking about getting back to what is more of a normal state until there is a widely available vaccine and/or therapeutic treatment. Earlier today, AstraZeneca, a British company that's been working, a European, I forget exactly where they're from, but they're a European company that's been working with Oxford University in England, released promising results, and it's kind of suggested that by the end of the year, they're going to know whether that's going to be a viable vaccine. But of course, there's a rollout period. So, this is not something that's imminent, and we're going to have to continue to deal with this over the mid to long term. This slide is just a reference to our Oregon Health Authority dashboard, which shows where we currently are at in the state. And I like this resource a lot because it if you go to certain sections, it shows you where certain counties are, what the indicators are, what the trend lines are. It can either make you feel really good about how we're keeping case counts and deaths down, or, make you feel bad that Multnomah County, despite really having overall a very low infection rate, is still missing 4 of the 6 categories that it needs to get into phase 2. But as things change, this OHA resource will be good to kind of gauge like how close we are to, pre-COVID normalcy. Once again, like I said at the beginning, I'm a litigator, and so that informs a lot of my, where I look at these employment law changes and what I'm thinking about when I'm trying to protect my clients from certain situations. Early on during the COVID relief bill negotiations, there was a lot of discussion about employer immunity if an employee gets COVID. And a lot of people were frustrated with the fact that employers could be reckless in putting their employees in situations where they might get sick and not be able to be held responsible for that. That's the national discussion. In Oregon, it's different. So going back to the progressive era, almost 100 years ago at this point, Oregon enacted one of the very first workers' compensation systems in the country. Part of that workers' compensation system was creating a balance between the employer's duty to create a safe and work environment, as well as not creating an overly onerous system that could put them out of business if one of their employees got hurt. So generally speaking, employers in Oregon are required to get workers' compensation insurance that provides for the payment of medical bills, wages, and other things if an employee gets hurt on the job. In exchange for that, employers from their direct employees are immune from most types of litigation relating to workplace injuries. The workers' comp system was exchanged for immunity for employees on these certain types of things. So how does that interplay with what's going on with COVID? Can an employer be held liable for an employee contracting COVID, or are they immune? Is a question that has come up. And secondarily, are there any exceptions to that? So generally speaking, first of all, diseases are a little weird. It's often kind of difficult to associate whether or not somebody contracted a disease at work. Just because of how, this is an airborne disease, we have all different types of contact where we could contract this thing. So tying it directly to work would usually be hard. If you think about the flu or all of our pre-COVID type interactions. COVID's different because we have contact tracers. We have a better understanding of how it's actually transmitted than a lot of different diseases that you might get. So this is one where, this is not settled law, but I think that there are going to be situations where employees are going to submit work comp claims for contracting COVID at work, and that it will be covered. But setting that aside, there are always exceptions to the general rule of immunity. And in particular, those are intentional conduct, unprovoked aggression. Subcontractors who are not your employees do not fall under the general work comp immunity statute. The negligence of somebody who's outside the system, that outside of your employment, that causes the harm of an employee, that also might not be covered by the work comp immunity statute. And then there's certain industries and other kind of nuances within the statute and the common law that have developed over the years that are carved out. So in general, there should be there will probably be, when this is ultimately all litigated and figured out, immunity for employers in Oregon related to contracting COVID at work. It's still an open question. And even when it's decided, there's going to be, kind of carve outs and definitions that have been created by courts or agencies that go to that. But the good news is it's safe. The work comp insurer that most Oregon employers use is saying that, look, this is something that we're going to cover. There are all sorts of situations though where it might not be. And that's going back to the previous slide. The one for me that I think about the most is causing problems is subcontractors. So you've hired somebody who's not, your typical W-2 employee, and you've got them on a 1099 and they're coming in every day, and for whatever reason, they contract the coronavirus, and that is a situation where potentially an employer or a business could be held liable. So setting up systems that help prevent that is important. And it becomes particularly important right now because one thing that the legislature did in reaction to the coronavirus was it extended the statute of limitations for certain types of tort actions. So probably the types of lawsuits that we're talking about here aren't going to be affected by that law. But right now, if you had, most tort statute of limitations are 2 years. So if somebody slips and falls in your store, if it's been 2 years between that accident and when they file suit, their claim is barred. They can't collect any damages from you. But right now, because we have had the courts closed, the courts on limited capacity since March, the legislature said, we're going to extend the statute of limitations on all of the cases that would have had their time limit expire since March up until at least, I think, December under the the governor's current order, for at least 2 months after the governor lifts the emergency order. So there are going to be slip and fall cases that happened in March of 2018 that will be able to be brought in January 2021 or later. This is a big change, and it's something to really kind of keep in mind. Your insurance carrier, you personally might have known of something in the background that you're just waiting for this to go away, but it's not necessarily gone yet. Personally, I think that law might have some issues in our appellate court, but as it's written, we won't know what the appellate courts are going to do with it for at least a year or two. It's just something to kind of keep in the back of your mind as you're thinking about your liabilities. Anyway, getting back to your employees, like I said, Oregon's a little bit different. We already had something built in to protect employers in these types of situations that's different from other states. So thinking about what you need to do to prevent or to mitigate against the potential risk of a lawsuit from an employee or somebody who's coming out from outside. There are guidelines and guidance from the local, state, and federal government about how to operate a business, what types of things you should be doing. The Oregon state government has put together some really nice phase 1, phase 2 checklists for certain types of industry. Bars and restaurants, personal services. I forget if there's a retail one up there, but the link to those is on the PowerPoint right there. And it's really useful as you're, making sure that you're doing all the things that you should be doing to keep your business operating, in a safe fashion to protect, your employees, your customers, as well as your business and yourself as a business owner. As mentioned before, this is all in flux. There's a lot changing. So as time goes on, staying up with what the governor's executive orders are saying, what the federal guidance is saying is important. It's all on the website. They've been very good about updating it and keeping it transparent. Usually the local media, NPR, and the Oregonian have been good about publishing when these changes come into effect. They aren't always good about describing exactly what they mean. So it's good to kind of, get it from the horse's mouth, see what the governor actually put in the order, see how the agencies are interpreting these rules that affect your business, rather than just relying on the media. And again, if you have questions, seeking out legal assistance in trying to, figure those things out is the best practice. You know your business the best. You know how your people work, where they work, how they interact with each other and the public. So thinking about the science that's come out and the CDC guidance on how the disease is transmitted and how you think logically you can protect your folks is important. As we know now, this is an airborne disease that creates challenges depending on your work environment, how things are set up. So thinking about that and creating systems, whether it's rotational schedules, work from home, creating new barriers, mask rules regarding having office doors closed. There's all sorts of things that you can start to do, which always should go back to how is this thing being transmitted? What can we do to prevent the transmission? Specifically in Oregon, and this is very closely tied to the phase 1 and phase 2 restrictions for retail establishments, restaurants, and other types of places where you have a lot of people coming through. You want to know the maximum occupancy of your building and the appropriate level reduction or applicable restriction, like with restaurants, it's 6 feet apart for tables, things like that, so that you can continue to operate while doing it safely and in compliance with the law. I mentioned modifying employee schedules earlier. Personally at our office, we have on days and off days for our attorneys. I'm a Monday, Wednesday person, and then we have Tuesday, Thursday people. If you have to be in the office for a client meeting or something else, you can let the office manager know, and that way there can be a determination about whether we have enough space on that day or in a particular conference room to do that type of work. That's a good practice to the extent that you can do it. Obviously, different types of businesses will have different restrictions, and you got to think about that and how to work within those rules to keep your people safe and comply with the law. We already talked a little bit about the physical barriers, so I'm not gonna harp home on that. But we are in a time where our positivity rate is increasing, our case count overall is increasing. So while back in March, you probably did not have an employee who tested positive or exhibited symptoms. Coming into the fall, with the numbers going the way they are, that might happen. We're going to talk a little bit about what to do if that does happen in the next couple of slides, but really, if somebody seems like they're sick, they need to go home. You need to protect the other employees. You need to encourage people to use their sick leave as appropriate. You need to make sure that people, once they come back in, are healthy. You don't want to be in a situation where you're putting everybody else at risk. Cleaning, encouraging hygiene, all of those things. Less travel, more Zoom. I know we all hate it. Thank you for being on here today, but I know you'd rather probably be in a conference room with a nice, breakfast spread like we used to, but we're still a ways away from that. Because all of this guidance is available online, because we've been talking about it, because it's generally more in the zeitgeist, and the public discourse than a lot of other prior diseases or other issues that you might have had with relation to operating your business. Standards regarding what will be considered negligent conduct, what an employer knew or should have known, the precautions that they should have taken, those types of things, I think, when ultimately all this gets figured out in the court, there's going to be a higher burden on employers than there might have been for other types of workplace injuries. I just think that because we know what we're supposed to be doing, because it's broadcast, courts and people, juries, are going to hold people to a higher standard once this stuff starts to get litigated. So again, it's important to keep those things in mind and set up systems so that you're able to avoid problems. So last week, there was an update in the state's mask rule. It expanded when people should be wearing masks. And it also suggested that the plastic face shields, which have become more popular, generally are not the proper piece of equipment to be used to protect people from transmission of the virus. So, this is Portland, and this is a group of people who I'm sure have been doing the mask thing before the governor mandated it, but it's important to kind of keep up with, what is appropriate use, how, which things work, which things don't, to make sure that you're keeping your employees and the public safe. Exceptions to general mask rule is if there's a medical or other condition that keeps somebody from being able to safely wear a face covering. As an employer, like a lot of reasonable accommodations that you might do under disability law, you can ask for proof of a doctor's note for that situation and engage in an interactive process, talking with your employee about the restrictions that they have and what you can do as an employer to create a work environment that is safe for them and not unduly burdensome on you. For example, that could be the use of a face shield or creating a glass barrier at a desk or giving somebody an unused office when they would normally be in a cube. Things like that, are things that you should be thinking about and doing if you do have employees that have respiratory or other issues that would prevent them from wearing a face covering. I haven't heard this talked about a lot, but one thing that I was kind of thinking about as preparing for this is, can an employer require an employee to supply their own mask? And the answer is, with non-minimum wage employees, yes. Minimum wage employees have a carve out, those employees that earn minimum wage are exempted from having to buy anything but very simple uniforms and equipment for the job. If somebody's minimum wage, those are things that typically have to be provided by the employer. So generally, with your non-minimum wage employees, you can tell them bring your own mask. With anybody who's minimum wage, you probably want to provide a mask for them. The best practice is to always have masks on hand, some of the disposable surgical ones that you can give to people who are coming into your space that forgot to bring them, or that, just might need one for whatever reason. Talked a little bit earlier about, what this disease is, and, our understanding of it is evolving, but it's important that your employees and then anybody who's kind of responsible understands the symptoms. So if you do encounter somebody that you suspect of having the disease, that you can take the appropriate action. So currently, the most kind of prevalently known symptoms are fever, cough, vomiting, diarrhea. You've heard about the COVID toes, COVID fingers. It's like the purple purplish fingers, blackened toes that you've seen on some people who've had either minor cases or severe cases of COVID, and then tiredness, malaise. If your employee, letting your employees know what this looks like, either through the posters that are provided by the state or just sort of general distribution of information to employees, they should know that if they're having any of these issues, it's time to take a break, stay home, get a doctor's note, get checked out, and make sure that they're not coming in and spreading it throughout your workforce. Having an understanding of that as the employer is important. Making sure that your employees have an understanding of what this is about is important so that they can take the appropriate action if needed. One thing that, I've seen it kind of go in ebbs and flows with employers, with their workforce, as well as at certain establishments, are these health checks. This is something that, nobody would have ever considered doing before the pandemic, but it's kind of like in that zone where it's getting to be a more prevalent thing. You don't have to do this. A lot of people do it, especially in workforces where you might be in a more open area where transmission would become really, it would spread quickly if you were to have an employee in the workforce who contracted. Specifically, you see the reports of food processing facilities having the relatively major outbreaks. That's sort of the one that comes to my mind. If you've ever been to one of those, people are packed in pretty tight, and there's a lot of people all close together, and you can just see it in your head going down the line between person to person. Kitchens, I think, are another situation where you just, because of how most commercial kitchens are designed, you're packed in tight. There are office situations where you might have office pods, those 4 cubicle desks that are all together. If one person were to get it, the next person's only a few feet away. Even if they're masked, there's a risk. So in situations where people are going to be more tightly packed in, just sort of because that's the business, it's probably a good idea to do some type of screening at the door, whether it's temperature checks or having people confirm that they don't have symptoms. You don't have to do it. Priority is to get your employees thinking to do it themselves and to be proactive about it, and letting them know affirmatively, if you are sick, it's okay that you're not here. We're not going to retaliate against you. Your job's still going to be here. Take the time to get healthy and keep everybody else safe. Like, having that message where employees feel empowered to take the time that they need is super important. And I think that, and not just in a COVID situation, but generally speaking, because if people are concerned about taking time off, or if there is a culture of fear in your office or your business around missing work because you're sick or you had an emergency with your kid, that's the type of thing that leads to lawsuits. And that's the type of thing that makes verdicts bigger, when people can point to situations where people were retaliated against, or managers made people feel like they couldn't take the time that they needed. So important to begin with. Employees should self-screen, encourage them self-screen, encourage them to take the time off. But also, if you do have a situation where people are tacked in, think about what you're going to be doing at the door before people come in and create a transmission risk. One of the things that you need to be very concerned about if you are doing temperature checks or other types of screening is violations of privacy. There are laws like HIPAA and GINA and a few others that are very, very tightly restrictive on an employer's ability to, well, not just an employer, but anybody's ability to take somebody else's personal health information and share it elsewhere. So, I'm aware of some businesses that have had people record their temperatures in like a logbook. That's problematic because if other people are seeing your other employees' temperatures, that's a potential violation. Same thing with, symptom checks. You might be an app-based thing. I have an app on my phone. I think it's called How We Feel from one of the federal agencies that you can check in on. And I could see employers having something like that, but you don't want to share that with other people. It might seem minor or petty, but just you're inviting problems if it's in a public fashion, and you're inviting problems if the employer is tracking it and keeping it. So it's better, use your little thermometer gun. You see somebody who's got a 100-degree temperature, you send them home then, and rather than writing it down, tracking it, it's just the better way to go about it. Finally, on this slide, the testing. So as an employer, you can't force an employee to go and get a test and pay for it themselves. You can require them to get a test before coming in or returning to work, but you have to pay for it if you are requiring them to do it. Generally in Oregon, the guidance is right now, consistent with the CDC, is if somebody is not exhibiting symptoms, unless they've been exposed to somebody who was recently diagnosed, there's not an advice to go and get testing. Everybody's handling this differently, but these tests are expensive. And, if somebody had to do one every day when they came in, it's not practical. But if you are aware that somebody was in a situation where they were exposed, getting them checked out or quarantined for a time before they're able to come back is a good idea to protect your staff and your customers. So what do you do if an employee contracts COVID? First of all, we're talking about self-screening and making sure that your employees feel empowered to take the time that they need if they're sick. But if you observe somebody with symptoms, you can send them home, and you probably should. Sick employees should always be encouraged to stay home if they are, and you should let them know about the leave laws that are in place if they're applicable to your business, so that people can understand that my job is safe. I'm going to be able to come back when I'm healthy. And in Portland, there's a certain amount of paid leave that is required for certain size companies. That leave can also be available, as well as the unpaid leave that's available under other statutes. So if you're aware that somebody's sick, they're showing symptoms, you can send them home. You can require them to show, proof that they're better before letting them back in or having a quarantine period. But you want to keep your workforce safe. The other thing that has been coming up a lot is if somebody tests positive, what am I doing with regard to informing everybody else? Again, you have to be concerned with privacy, the privacy of the individual employee here. So if you do have somebody test positive, you should let the rest of your workforce who's been in contact with them, or more broadly, know that somebody in the company was infected, so that they can personally take the actions that they feel that they need to do. You shouldn't give out the person who tested positive's name. Significant privacy concerns with that opens you up to liability if you do. But if the employee feels personal responsibility to share that, that's fine. You just don't want to be, as the employer, saying, Jim tested positive for COVID, everybody should go get tested because of Jim. It's problematic. Don't do it unless you have express permission. And then finally, the OHA and others are encouraging people to let them know so that they can do the contact tracing and the steps to help us mitigate the virus risk. So another recent rule that was just made for OFLA, and not all employers are large enough to qualify for OFLA, so got to make sure that you are actually an OFLA employer before doing it. And even if you are big enough, you have enough employees to be OFLA eligible, not all employees are going to be eligible employees of that program because they have to work a certain number of hours. But if you do fall into that category, the state government just passed a new rule that because a school closure is now a justified reason to use Overflow Leave. So basically, everybody in Portland from this year could, who has a child that's been kept out of school, could use that leave, the 12 weeks of leave that's available under OFLA, without pay and without fear of retribution or losing their job. So it's something that's new. It's going to create some pressure on employers, I imagine, but it's important to know about it. The rules with OFLA and FMLA, which is the Federal Medical Leave Act, are changing frequently. So it's important to stay on top of those as the pandemic continues. I mentioned earlier that Oregon updated its anti-discrimination law. Just like any other type of disease or disability, you can't discriminate against somebody for contracting COVID. Kind of sadly, there have been some cases where because of national origin, race, or religion, there's been discrimination against particular groups of people related to COVID, usually among Asians. And you want to prevent that specifically, and you also want to mitigate against the risk that somebody's going to feel like that, feel singled out, preventing the, and it's difficult because our president's rhetoric has, put into the common discourse things that are pretty outright discriminating with regard to this particular issue. So keeping that out of the workplace, keeping people feeling safe and comfortable and supported, and treating people across the board with respect and dignity with regard to their diagnosis is crucial to avoiding potential problems. These problems that might come up are, they're going to be around for a while. One of the things that this new law did was it increased the statute of limitations on discrimination claims to 5 years. Until October 1st, it used to be 1 year. So, if you're thinking about this, if somebody felt like they were fired because of a COVID diagnosis this year, it'll be 2025 before the potential for liability ends. So it's another thing to keep in mind when handling your workforce and making decisions. Like I said, this has created a lot of economic pressure on people, and there have been difficult decisions to make. Workforces have had to be reduced. So one thing that I've seen problems with some of my clients is failure to appropriately pay the final check. So this slide lays out, what happens when an employee leaves and what happens when an employer has to let somebody go. And really the payment has to be made promptly. And that payment has to include things like ancillary benefits and leave if it's allowed under your particular employment agreement. So, one thing that I've seen is that we've had employers that have laid people off and they get 10 days of leave a year, and it's accrued on a weekly basis, and they don't pay for that leave. And there's a presumption that if you don't say that the leave is excluded, that you actually have to pay people for that leave, that time. It's their money. So making sure to calculate those checks accurately, get them out timely, because if you don't, can be hugely expensive. And there's a lot of class action cases when you have a large number of layoffs at all the same time, where all the checks were calculated incorrectly or sent out at the wrong time, and it adds up. It can be a month's worth of unpaid, a month's worth of wages plus the unpaid wage, attorney's fees, costs, and civil penalties. It can bankrupt businesses, these class actions. So it's very important that if you are letting people go, to make sure that you're processing checks fully and appropriately and timely. I talked for too long, as I want to do, but we've got about 5 minutes for questions if there are any that have been raised by this discussion. I really appreciate everybody coming out today, and thanks for all your time.
Oh yeah, yeah. It's. Thank you for all that information, because it was definitely jam packed with a lot of valuable things that, quite frankly, you actually did address in the presentation with some of the questions that we're seeing. And so one in particular that was one of the more recent questions was, if someone does get sick with COVID, what is your responsibility to tell other employees and customers? And I think you laid out what that answer would be in the presentation very, very nicely. And would you like to comment a little bit more about that?
Yeah, I mean, the privacy thing is really important. You don't want to, address a problem by creating another. So be very careful about the information that you divulge, but you do want to let people know so that they can take the appropriate action. You can address some of these things by having communications with your folks. So for example, if, at my office, if one of our paralegals in a work pod was diagnosed, I could ask that person if they would be willing for me to let them know that the other 3 people, specifically that it was somebody there and that they were close and they should really get tested because of the proximity. You can get that approval. It's best to get it in writing, informed consent. So that's sort of best practice. But yeah, it is important to let your folks know about potential risks, simply because you don't want to create a situation where, one, there's an outbreak and you don't nip in the bud the other infections, and 2, just people feeling lied to, deceived. When people's personal safety is threatened by a situation, it can lead to all sorts of reactions that aren't create liability problems, but really it's morale and business operation problems, more particularly.
Okay. And then looks like another one came in. It is great. It is a great reminder how health information is not only private, but legal private. Okay, yeah, so that was just a comment from Robert about just the importance of privacy. And then I think the first one we see is, how can you find a list of HR outsourced firms that work with small businesses, as you referred to earlier in the presentation? And should you have folks sign waivers when coming into your workspace? I noticed hair salons and nail salons are doing this. So yeah, could you touch on those 2 questions a little bit?
So, you asked me about the HR firms first, and I know there's one called Xenium HR that I think does good work. Xenium. I'll have to think about some others, but if you Google it, there are quite a few in Portland, and most of them I thought have been pretty good when I've worked with them. With regard to waivers, there's sort of a mixed, I think that waivers are a good idea, but I think that you can't be too reliant on the waiver, because the way the law works in Oregon, you can waive negligence in most cases. So if there was an accident that led to harm, that's something that could be excluded, but you can't waive recklessness or intentional conduct. And so the waiver is probably going to provide some level of protection, but a creative plaintiff's attorney is going to be able to frame it in another way where they can sue you. The thing that I think is most valuable about waivers is not necessarily like protecting against litigation. It's providing folks with information so that they're thinking about it, and so that if it does happen, it's not like it came out of left field. For example, if you are in a hair salon or a nail salon, you're in close contact. I mean, people know that breath and being in close contact for periods of time creates a risk. Putting that in paper in front of them, letting them know, it's certainly going to help you at a trial. And I think it's probably going to help people who are making the decision whether or not they want to do it No, if they're the type that it's going to get concerned about it and is going to overreact, they're going to see that they might not do it. And if they're going in and they do it, they know what's happening. So I think that they're a good idea, but they're not a total shield to liability, total shield to litigation. Liability, most of the time they should do a reasonably good job, although in the COVID situation, they have not been tested at all yet. So it's an open question.
Okay, cool. So yeah, I guess, waivers are good, but they're not the end all be all.
Yes.
Okay, and I guess the silver lining is that it's an opportunity to provide information for those so that they have a better understanding of how things are.
Yes.
Okay, great. And so I did put in the chat Xenium HR, and I found their website, so I was able to link their website in the chat. And so if anyone is interested in Xenium XR or Xenium HR, they can find that information in the chat. And if anyone else wants to unmute their mic and ask a question, we have about 1 more minute, and so feel free to do so. And if not, we will, it looks like Robert does. And
yeah.
So, yeah.
I want to thank the Seoul Business District. Great idea to have this COVID series for surviving and getting through this pandemic we're going through. I mean, this is very valuable information. Greg Lockwood, thank you for from working with Seoul District, letting us get in here. And we had questions on chat. That's good. And don't forget Jimmy Wilson. I gave you my phone number there. Give me a call, Jimmy Wilson. Haven't seen you in a long time, my man. So Greg, thank you, man, very much. And I'm gonna stay here till Stephen clicks me off, because this is good stuff.
Okay. Thank you.
Okay, thank you, Robert. And then I believe Dennis Williams.
Hi, sorry I was a little late to this, but thank you. Very informative. And I think that this will be very helpful to the entire community. Thank you for the invite.
Oh yeah, thank you. And excited to be working with Greg, and obviously with Bryson was it 2 weeks ago? And look forward to continuing this series to help give you enough information to navigate this crazy time. And so if there aren't any other questions, Greg, again, I thank you. And
Stephen?
Yeah.
This is recorded, right? So
yeah.
If people want to watch it again or share.
Yeah. So I was going to go to the outro. Okay. But yeah, so if you would like to listen to this presentation again or share it with others, this will be available on Flossin Media TV's YouTube channel and on the Seoul District Business Association's website. And so just go to www.seouldistrictbiz, Seoul District as it's spelled out, and then biz.org. And if you have any other questions or ideas about the series, please contact Flossin Media in the Seoul District at 503-841-5032. Again, my name is Stephen Christian, and I was your host for this. It's hosted by the Seoul District and Flossin Media. Our guest host was Greg Lockwood. And if there's anything else you want to say, Greg, feel free to. Otherwise, we will head off.
Thanks again. Good luck to everybody. And if you want to reach out to me, my contact information is on the firm's website. I'd be glad to chat with you again. Thanks again for having me.
Oh yeah. And so look forward to the next episode, which will give you guys a little bit more information later on in the next coming weeks. And be safe, everyone.
Thank you.